All right, so what's happening with this case?
Judge, we think we have provided all the discovery.
Everyone, please whisper. Yes.
I would like to ask for a little more time to contact the complaining witness in this case.
All right, in defense, do you have all of the discovery?
We have them all, Judge, just on the computer. I'm thinking that we do have all of the videos, but as I was looking at them, some of them, for example, wouldn't play yesterday. Then I just tried some of them on my phone, some of them were working, so it's.
Okay.
Only hesitancy, Judge, is that I haven't been able to play them all on my computer or my phone, because I tried to show them on the phone that it wasn't working, and then it did. So.
All right, Miss Ferguson, on April Rose Garcia, can I have a 30-day reset? That's going to be your final date for discovery and the date to contact complaining witness.
Yes, ma'am.
All right, we'll be back on May 20th. Once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, you're welcome. Are the parties ready on Ray Anthony Espinosa? Hello, good morning. All right, and defense, make sure you get a copy of the motions I've signed on.
Thank you, Judge. I appreciate it.
Okay.
I'd have to look at it.
All right, so the last time we were here, there was a discovery for the hard drive
Correct.
and you all exchanged hard drives?
We did.
Okay, and then that's where we are. We're here now for more discovery. Do you think you have all of the discovery?
So the situation is, Judge, it appears that there has been a new allegation leveled against the defendant while he has been in jail.
Okay,
And Michael De Leon was somehow appointed to that case.
okay,
So we're just waiting on him so that we can do a little bit of a swap so that Mr. Bali and I can get the discovery on that new
Okay.
offense. I don't think we need to exchange hard drives for that. I think we just need to be able to upload it from the e-discovery system.
all right. So this is what I'm going to do on this case. And y'all will need to confer off docket a little bit.
Okay.
I'm going to give you, because of the nature of the offense
Sure.
and because there's more than one charge,
Yes.
I'm going to give you all a 45-day reset for
Got it.
discovery.
Okay.
When we come back, all discovery needs to be prepared and you all need to be prepared to do an acknowledgement of discovery. Is that possible?
Yes, I believe that is possible.
All right. Ms. Ferguson, on Ray Espinosa, I'm going to need a 45-day reset.
Yes, ma'am. I can do
That's perfectly fine.
All right, June 3rd. I am back to writing 2023 for some reason. So, and then counsel, if y'all would like, do you need a third attorney on this case? Because then Michael could stay on that case plus on this, if y'all would like.
It's fine with that. It won't make any, if that's what the court would like to do, that is perfectly acceptable. However you'd like to do
You
it.
want me to ask Michael when he comes in?
Yes. And then, I don't know, if there's extraneous stuff, maybe he can handle the extraneous
Yeah,
stuff.
and there are 3 misdemeanors. There's other stuff. So
All right.
that's fine.
All right. So if you can see when Mr. DeLeon will be here.
He said he'll be on his way, Judge. Could you ask me to contact him to come for the other client?
All right. Thank you.
I'm gonna go in.
All right. Is there anything else on this case?
I don't think so, Judge.
All right. So they say Mr. DeLeon will be here shortly.
Thank you, Judge. Okay, thanks. I'm gonna go get those copies.
All right. What is happening on this case?
I was just appointed yesterday.
Okay. So,
Not much we can do with it today.
well, have you got discovery? Have you looked at discovery?
I looked a little bit at the file. I've talked to my client and the witnesses, talked to the prosecutor. If there are any videos or anything, I would like time to be able to watch them and download them. I haven't even had a chance to do that yet.
All right, Ms. Ferguson, if we can have a 30-day reset on this, please. That will be your final discovery date and state will need to be prepared to make an offer at next setting.
I can do the 21st, May 21st.
All right, you'll be back on May 21st. Once you sign the reset form, you're excused.
Thank you.
Thank you for dressing appropriately for court.
Thank you, ma'am. Sorry, this is the best one I had day.
Oh, no, it's great. All right, once you sign the reset form, you're excused.
Thanks, ma'am.
All right, this is family violence. Where are we on this case with discovery?
We have requested CPS records, but have yet to receive them, Judge. Once we do, it'll be in a different ballpark.
All right. So what's the time frame on the CPS records?
I'm not sure, Judge. I'm gonna reach out to the intake side and see if they have an update specifically with respect to timeline. So I don't, it was done late February, either
Mhm.
February 28th or if this is a leap year, whatever the last day would be.
Mhm.
So we're just in like a month-ish period, month and a half-ish. So I apologize. I don't have an exact
No
time
problem.
frame, Judge, but I will follow up with the intake side today.
Do you have a legal case with CPS?
No tienes delito con CPS.
No.
All right.
You said,
Ask him,
you said they interviewed him at the jail, Judge, and that's all they've done with him.
all right. Does he have a CPS attorney?
¿Tienes un abogado con? No.
All right. So is your client a citizen?
No.
All right, Norma, he needs an immigration attorney. Are you retained?
No, Judge.
All right, so he needs an immigration attorney. And next time, council will need the interpreter here. And it sounds like if they interviewed him at the jail and it's this, you may want to reach out to the prosecutors in CPS court. They may have the records.
Yeah, Judge, I'm gonna write that down. Thank you, Judge.
Sure.
We can do Max. Max is the only.
Yes. All right, and then let's recall this in 30 days.
21st of May.
All right, we're going to come back on May 21st. Is there a chance that he's going to be released or is there an immigration hold?
Immigration hold, Judge.
Okay. All right, Norma, then he's done.
Thank you.
Thank you, Judge.
You're welcome.
Have you excused it?
Yes.
Apparently this morning, Your Honor, his wife, co-defendant, got 30-day reset with Attorney Simmons.
Yes.
Looking for the same day, pretty please.
Yes. All right, so that is going to be May 20th. And thank you for dressing appropriately for court.
You're welcome.
All right, so that's going to be the final discovery date. All right, Ms. Ferguson, on Joel Francisco Garcia, if you can set this for May 20th, please. All right, thank you.
Thank you.
And once you sign the recess, don't be excused. Samuel Bach. Hi.
Hi, good morning.
Thank you for dressing appropriately for court. All right, so we are here and today is plea deadline day.
And Your Honor, we have received the plea offer and we have rejected it.
Okay.
We will, this is a complicated case. We will need to approach the court ex parte on some issues, as well as need time for investigative work, additional investigative work. There are medical records in this case that we need access to that we don't right now. We're working with the court, but
Has anybody subpoenaed the records?
we haven't subpoenaed them because we just got to the point of realizing we cannot work it out, and that requires going to the family of the complaining witness who's deceased. And before we went that route, we were trying to figure out if we could work it out.
All right, Ms. Ferguson, on Samuel Bach, set this for jury trial within 60 days. That's your trial date. Because this has been on the docket since January.
And with all due respect, it has not been the defense that has been asking for the resets. It has been the state so that they could confer with their complaining witnesses.
Well, I mean, I'm saying it's been January as it relates to discovery. So,
And at the last setting, and they let us know that there was medical records that actually were relevant that we don't have access to that are of the deceased. So that were relayed to them by the complaining witness's family. I just spoke with the complaining witness's family. They don't have those records at this point, so.
and see, this is the court, and I'm not trying to be combative, but this is what I don't understand. I don't understand why people don't go forth and try to seek out all the discovery. It seems we're in the information age, but people don't want information. It's the nature of this case, I would think, and if I'm wrong, correct me, it's a manslaughter. I'm thinking automatically there has to be some medical records and people would want those medical records. So it's going to be set for jury trial within 60 days and you all subpoena whoever you need to subpoena and whatever happens, happens. But discovery has been going on since January of 2024. And here we are in April and no records have been subpoenaed. So, Ms. Ferguson.
June 11th.
All right, June 11th is going to be your jury trial date. Once you sign the reset form, you all are excused. All right,
No,
thank you.
I apologize. Can I get some clarification? Is that the announcement or is that the picking of the jury?
Let me see.
Tuesday, it's the beginning of the.
Yep, pick it, selecting of the jury.
Okay, is it possible to also then have a date the week beforehand to come in to handle any pretrial matters or?
Oh, you'll have to just schedule that with Ms. Ferguson.
Okay, all right, because we are gonna need pretrial
Sure.
motions and stuff.
All
Okay,
right, thank you.
thank you.
You're welcome. You're welcome. All right, and where's your client?
At the jail now.
That's right, Judge. This is the similar kind of mental health sphere that is similar to the other paperwork.
All right, does anybody want to write this out so it's legible?
Yes, Judge, I can help out with that.
All right, thank you.
Should we start?
Who's here on Walter Jean Cerner Martinez?
Me, Your Honor.
All right, and where's your client? So thank you for dressing appropriately for the court
Of course, you're on that.
and with a little fiesta thrown in. All right, what's happening with this case?
Judge, I just got hired on this case. This is the first setting on MTR. He did report to his officer Borrego 2 days ago. She instructed him that she would like him to do a retreat, very active at church. And so do a retreat on May 2nd. I would like to see if we could put a date beyond that to verify.
All right, state. On this case, he's saying that he was just retained, so he's asking for a short reset.
That we're not opposed, Judge.
All right. So, Ms. Ferguson, probation on Walter Jean Cerner Martinez, defense counsel is asking for a reset. He was just hired. So what we'll do is we'll set it for a contested in 30 days. And if it's not, it turns out it's not contested, then it won't be contested.
Thank you very much, Judge.
Oh, sure. Just one moment. Let me get a setting.
You can say contested, Judge?
Yes, it's going to be on Walter Jean Cerner Martinez. It shouldn't be that many.
May 9th.
All right, May 9th. All right, once you sign the reset form, you're excused.
Thank you
And
so much.
sir, you need to make sure you stay in contact with probation. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you so much, Judge.
You're welcome. All right, on this case, so an offer was tendered.
Yes, Judge.
All right, and has your client had a chance to speak with the immigration attorney?
We discussed this last time, Judge. The charge is murder, so it
Yes,
doesn't have
we
any
know.
bearing. It'll be automatic deportation if he's convicted of the charge and then released after his stint in prison and or probation.
All right, and you have all the discovery?
I have all the discovery. They just finally got the transcript of the translation of the interviews. Is that right?
Correct.
All
And
right.
So I'll get that. Last time we were here, Judge, my client brought up the issue that he wants another attorney.
Mhm.
He's upset with me because I won't file a motion to withdraw. At this point, there's still not a conflict.
Okay, all right, so here's the thing. Mr. Moreno Vasquez, I want you to hear me and I want you to internalize what I'm saying, okay? If you want another attorney, you need to hire one. Do you understand?
Yes.
I don't know what the issue you may or may not have with your attorney. Sometimes the issue people have with an attorney is they're not getting the offer. They're not getting the offer that they want. Here's the thing. I've been a defense attorney. I've been a prosecutor. In this court, I require that the state tender an offer to the defense. You can either accept it or reject it. Or you can tell your attorney, I'm accepting it, in which case we will do a plea bargain agreement. Everyone, please whisper.
Thank you, Judge.
If they make an offer and you want to accept it, then we'll do the plea paperwork. You will enter your plea. If they make an offer and you say, I'm not accepting it, then one or two things will happen. Either you go to your attorney and say, I'm not accepting this offer, but I will accept A, B, or C offer. That is what's called a counter offer. Your attorney will take what you will accept, if that's the case, to the state. And then at that point, the state can say, all right, we will accept the offer that you want, or as we call it, the counter offer, or the state will say, we're rejecting that offer, and the only offer we will make you is the offer we made you. Do you understand?
Can I say something? Yes.
If you want to say something about what the state offer is, no, because I'm not allowed to hear that. Plea negotiations are supposed to be confidential unless you're accepting an offer. Do you understand?
Yes.
If you want to talk about the facts of your case, the only way I will hear the facts of your case is if you are entering a plea bargaining agreement or if there's a jury trial or a bench trial. Do you understand?
Yes, I just want to talk about my case, that's all.
No, the person you speak to your case about is your attorney.
Okay, si me lo puede cambiar, ¿no?
Yes, can you change attorneys or not?
All right, hear me clearly. Abogado, you need to hire one. I don't know why people think that when attorneys are appointed to them, and I mean no disrespect when I say this, it appears to me that sometimes beggars are becoming choosers. If you see somebody who needs food and you offer them a hamburger and they say, no, I want lobster. This is your attorney. There's nothing, absolutely nothing wrong with this attorney. If you want another attorney, you need to hire one. Do you understand?
Okay.
Sí, es que como ya tengo tiempo, sí, nomás, y nunca me ha dicho nada, pues, nomás estoy.
Yes, it's been a long time and he has never said anything to me, never said anything to me, so I'm just waiting.
Oh, well, here's the thing. You're here, he's here. He can say something to you today. But my question for you is, did you receive the offer? Yes or no?
No.
All right, so he said, I know, but if you will indulge the court, he's gonna tender the offer to you that the state has made. When he tenders the offer to you, I want you to internalize it, think about it, and then you will come back before the court and you will let the court know whether or not you're accepting the state's offer. Do you understand?
Sí, lo entendí.
Yes, I understood.
All right. Thank you. You're welcome. And please have a seat. If you're not on this case, court is calling 2021 CR 7016, State of Texas versus Jose Lozano. Can I have the parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Raymond Martinez, Mr. Lozano.
And are you Mr. Lozano? All right, we are here for sentencing. A jury found you guilty, and they found you guilty of the offense of theft, $300,000 or more as charged in the indictment. Have both parties had a chance to review the PSI report? State?
We have, Your Honor.
Defense?
Yes, Your Honor.
Any corrections or additions to the PSI report? State?
No, Your Honor.
Defense?
No, Your Honor.
All right. State, what are you requesting?
Your Honor, we're asking that you sentence the defendant to 15 years in the prison.
All right. And the reason?
Your Honor, the defendant was convicted of a first-degree felony offense in this case. Reading the TAP evaluation, he's shown no remorse for his actions. He doesn't say this was the result of being under the influence of drugs or alcohol. His story about how he says this happens is just not credible. Doesn't jive with the evidence that we saw at trial. He says that someone offered to sell him $300 worth of items, over $300 worth of items for $600 to $800. He says his friend brought the trailer to him. The evidence that was elicited at trial indicated that a window of the truck was broken. So it's pretty clear to me that he knew these items were, the very least he knew these items were stolen. But Your Honor, what he's convicted of is theft. And I guess the other part of this, the TAP evaluation, they talked about his home life a little bit. He says he has regular contact with all his kids, but evidence elicited at the trial was he's not paying any kind of child support to Edith Serrano. That was one of the victims, you may recall, Your Honor. Or I'm sorry, one of the witnesses at the trial, Your Honor. I just want to, I know you were presided over this case, Judge, so you remember the testimony, but Terry Kirkbride and his wife are moving from California to Florida, and they lost almost everything as a result of this theft, Your Honor. But what Terry said on the stand is what really stuck with me. And what he said is, the hardest part about this is that he lost things in this theft as a result of this theft, as a result of the actions of the defendant that cannot be replaced. So the hardest part of that for him were the photos that are just gone forever. The things that he inherited, the things that his wife inherited, they're gone forever. Items from his military career that are gone forever, damaged or lost. And so that's what I want to emphasize to the court. And the other part of the thing I want to emphasize to the court, Your Honor, is we're asking for this sentence to protect the community from these types of thefts. This property crime, I think, especially folks who are involved in the criminal justice system, we can get sort of jaded and think, well, nobody died, right? But these crimes are very serious, and this is the victims in this case lost nearly everything that they own. And so, Your Honor, we're asking that you protect the community from these types of crimes and sentence the defendant to 15 years in prison.
All right, defense.
Judge, if the court recalls from the facts of the case, I think Mr. Lozano's explanation is perfectly plausible. There was absolutely no evidence presented by the state in the trial of the case that he was present when that truck was stolen, or that he ever drove that truck, ever had contact with that truck, it was ever on his property. His suggestion that the guy brought the trailer to him to see if he wanted to buy it is consistent with somebody who did steal that property, trying to go and pawn it off on people. Him paying $600 or $800 for what was the contents is because all the valuables were already gone. All that was left was a bunch of stuff that after whoever stole it poured through it. He admitted, yes, my print is on the trailer because he showed it to me, and he wanted more money than I could afford, and so I didn't buy it. He offered me the other things that were there. The complainant specifically testified in his testimony, the things that were at Mr. Lozano's property that they recovered were of little or no value, right? If you look at the PSI report, when they go to the restitution, it says approximately $300,000. How can you approximate that when he's already been found guilty by a jury? Well, this court knows why. It's because her math was a mess. The complainant testified in the trial of the case that he agreed in writing a contractual agreement with the insurance company to settle for $240,000. The theft statute is very, very clear. It's the value of the property at the time it's stolen, not what you paid for it years before. So when you read their exhibits, and the jury obviously never did, they put no attention to the real evidence in the case. They felt bad for the complainants. I feel bad. We all do. They suffered a great loss, but they didn't prove he was the one who did it. They proved that he was a party to being in possession of some of the stolen property. That's why we had a jury charge all the way down to a state jail. That was the appropriate charge. This case is ripe and full of appeal issues, especially on the issue of the value and sufficiency of evidence. This case does not merit a day in prison. I get it. It's a big loss. But if you look at the exhibits, and I was going to bring it to you, but it's in the court's file or court board's file. USA went through an exhaustive list, and he says I spent months and I kept updating it, telling them all the things that I lost. They put the retail value, they depreciated it down to the actual cash value at the time of the loss, right? He signs an agreement, accepts the check saying $240,000. And that included the truck.
All right, so just so parties know, I'm not going behind the jury's verdict.
I'm not asking you
Yeah,
to,
all
I'm just saying the punishment should fit the crime.
Okay.
The jury did what they did, and that's for another court to look at, whether there was sufficient evidence for their verdict. But my suggestion is, if they've proven that my guy drove off with the truck and the trailer and he had gotten rid of everything, I can see that this is a different case. There's absolutely no evidence that was presented to suggest that. And his explanation fits squarely within the facts that were presented in this case. So I get it that there's restitution. My client is going to have a lifetime consequence because of his resident status of potentially being excluded from this country. So he is going to get punished severely by this court and probably another one. So all that being said, Judge, we'd ask the court to sentence him to a term of probation. We'll pay restitution to their number as best he can, as long as he can. But that's the appropriate sentence. If we're going to start locking up every person who goes to a flea market and those people that come into property illegally and they get it in their possession, we're going to start sending them all to prison. We don't have a big enough jail for that, Judge.
All right. Is there anything you wish to say?
Yes.
All right, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, and make sure you keep your voice up so the court reporter can hear. Who's the name of the friend that gave you these items?
Who's the name? I don't know his name. They called him.
Well, I mean, you say he's your friend,
Well, yeah, but
and you say you received a phone call from a friend.
yes, there's. Should have wrote it down.
All right, so here's my other question. The items, because there were some items that were related to his military career. When you saw the name of a person's name on military paperwork, what did you think?
At the point already, I had the stuff in my house. I didn't know what to do with it, didn't know where it was there. I bought it. It was in boxes when I bought it. By the time I got to open it, I saw the stuff.
So how much money did you pay for this stuff?
About 800, whatever was in the trailer, where I got it off, about 800 and $900.
Did you look through everything before you paid 800 or 900?
Boxes.
So you just take a boxes sight unseen, sort of like Storage Wars?
Oh, yeah.
All right. And so you don't know your friend's name who phoned you, according to you, it says that you were home asleep on this date and you received a phone call from a friend.
They call him Chaparro, but I at the top of my head, I can't remember his name right now. I'm
Okay.
sorry.
Oh, no problem. I just wanted that cleared up. All right, this is what the court is going to do. Court is going to sentence you to 6 years in the prison, give you credit for any time served. With regards to the amount, the court does not deal in approximations. So for the court, there is no restitution because there is nothing here to suggest a restitution amount. It just says approximately $300,000. There's nothing I can do with that. And this trial was on March 21st, 2024. So by that time, there should have been some amount to the court. So I'll give you credit for any time served. Is there anything else with regards to sentencing, State?
Judge, is the defendant's birthday, May 1st, 1998? Is that right?
You can ask him.
Okay. Is that your birthday, sir, May 1st, 1998?
Yeah.
And Judge, would you incorporate the evidence to trial as to the value? Would that be something you'd be willing to do?
No, because again, the amount that's listed in the PSI report is approximately $300,000. And then defense counsel is correct with the amount that the complainant settled for. And I know how insurance companies do sometimes.
Probably
The amount, yeah, the amount the insurance company settled for was $240,000. So this is where we are.
If I could, just one last thing on the record. I just wanted the court to be aware, the record to be clear, that approximation comes from the complainant. The PSI officer called the complainant to ask him that number, and that was his response,
Yes.
even after his testimony that was presented to the court.
I'm not ordering restitution unless there is some sort of deductible, which the court has not received any information on a deductible amount. So the court will sentence you to 6 years in the prison and give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor, we just have victim impact fees.
I do, Judge.
Yes.
We will be filing notice of appeal and request for an appeal bond. Do you want to take that up today or?
Oh, you have to file you'll have to file the motion and the court will take that up. So if you could have him fill out the trial court certification.
Well, they're gonna be filed today. That's why I'm asking if he could be kept in court today so we can address it, or. do you want us to set another
It's
hearing?
gonna have to be another date. All right. If you could have him do the trial court certification, so I could do that now, please. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, you have a right to an appeal as this was a jury trial. Once you file that motion, Ms. Ferguson will give you a date.
Yes, sure.
All right, you said there's brief impact.
Yes, ma'am.
All right. Are the parties here on Lozano? If you could start your video, please. Who's going to be the person?
It's Terry Kirkbride, Your Honor.
All right. Mr. Kirkbride,
Yes.
All right, you may begin with your impact statement.
Okay, I had no idea what to expect in this matter, but I see the sentencing's already been done. I'll just try to keep it short. I think the court's already heard most of our story. But I'll just go down the quick history. I mean, when we made our decision to move to Florida, it was to be near kids and grandkids. It was a pretty tough decision. I lived in California all my life up to that point. Sold our home, gave away pretty much all of our possessions that could be replaced, like furniture, refrigerators, that type of thing. All of our most precious items were packed up very carefully. It took us almost 3 months to get everything properly packed and wrapped. And I bought a 24-foot enclosed trailer, and that's where we packed everything in. On our journey to our joyous move to Florida to start a new life, we made it as far as San Antonio. And of course, from that moment forward, December 4th forward, it's just like our world was turned upside down. It derailed our whole joy of the move. And what was supposed to be looking for a home right away turned into almost an 8-month endeavor because we were dealing with all of the aftermath of the theft. I'm a combat veteran. One of my diagnoses is PTSD, so I was already dealing with that. And then this just totally derailed me and my wife and left us kind of in this state of like, what next? As we put the pieces together, keep in mind, it was 3 years, 3 months from the time of the theft to the time of the trial. And they had some 22, 23 resets. Each one of those resets represented to us is we had to juggle our lives around the schedule of the court. We gave up family vacations, gave up visiting sick family members. We did a lot of things during those 3.5 years, 3 years, 3 months that just kept this thing going. And now we're here at the final part of the sentencing and all that. And I feel for both sides. I feel for Mr. Lozano and how this must be for him. But I also got to understand what it was like for us. These weren't just things that you go to the store and buy. This was our life. My wife is a Native American studies. She had all of her research that was in those boxes that are gone. All of my VA records, all of our photographs of our family from the past, videos of the kids, all those things that cannot be replaced, along with all my military accolades that are gone. The impact was great. And I am glad that we're finally at a point for us anyways, where we can just kind of turn the page. I think that's enough said.
All right, Mr. Moreno Vasquez, you've received the plea offer from the state.
Yes, she gave me an offer.
All right, did you understand it?
La mera verdad no sé por qué me están ofreciendo eso. La mera verdad no sé por qué me están ofreciendo eso.
Honestly, I don't know why they're offering me
No,
that.
no, let me stop you right there. Here's the thing. You're charged with murder. That's what the state is offering. All I need to know from you is whether or not you received the offer. That's yes or no.
No, sí recibí la oferta.
Yes, I did receive the offer.
All right, so are you accepting the offer, rejecting the offer, or do you need time to think about the offer?
No.
Rechazar o aceptar.
Rechazar.
Rejected.
All right, Ms. Ferguson, state how long will this jury trial last?
On this particular one, it's codependent.
Okay.
And so it doesn't have a lot of moving parts, so actually case in chief, I'd imagine 3 days tops, but that's not including jury selection or the punishment.
All right, Ms. Ferguson, it's going to be a week for a jury trial on Mr. Marco Antonio Moreno Vasquez. And state, I know you have other murder cases upcoming.
Yes.
So if you want to speak to Ms. Ferguson.
And Judge, there's a codefendant case. They may want to go on a codefendant case first.
All right. Well, we'll put this down and we'll see who goes first. And Joseph Stateson,
Yes, Your Honor.
Monica Guerrero is on the co-defendant on this case.
I was hoping to announce after this announcement is finished.
Okay.
That's fine. I don't have any plans for them yet.
All right, September 3rd. Your jury trial date is going to be September 3rd. All right. You have any questions?
In 5 months?
Yes. And you'll be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to speak to your attorney and sign a clothing exchange.
I'll take care of that, Judge.
All right, thank you.
Thank you, Judge.
All right, thank you. All right, Mr. Stateson, are you ready on?
I am.
Okay.
Adis Rivas.
All right, Rivas Hernandez, come down. All right, Mr. Stateson, an offer was tendered to your client. Is he accepting or rejecting?
We received an offer. We conveyed it to him. The offer is being rejected. We're requesting a jury trial date.
All right, we'll put you for September 3rd.
September 3rd.
Yes, that will be your jury trial date. You'll be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you need to let your attorney know, and they'll do it at clothing exchange. Counselor, if there's an issue with the clothing exchange, just let the court know.
Yes, Judge.
Fernando Serrato. Oh, and Joseph Stateson, whenever you all are ready on that plea, just let me know. All right. Where is Fernando Serrato?
Custody judge,
Did you ask to have him brought out?
not yet, but it's a motion to revoke, and there are 2 new offenses alleged.
I require that they be brought out.
Okay, Judge.
All right. All right. Are you Karen San Miguel? All right, just one moment. All right, everyone. Whisper, please. Who's the attorney for Aria Eden Frosto?
That's Peter Calderola. He was here earlier. Good. I don't know where he's at.
You said the waive.
All right. Here. So, attorneys, I made this announcement at the beginning. And if people don't follow these rules, your day is going to get complicated. Do not request an inmate if you are not planning on staying in court. Hello, is this for a motion to revoke?
Yes, Your Honor.
All right, could I have a motion to revoke stamp, please? No problem, thank you. Okay, I'll pick that up. All right, are you all ready to proceed on the motion?
Yes, Your Honor.
Court is calling 2023 CR 0029, State of Texas versus Tyler Stephen Small. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Glenn Payne for the defense.
And are you Mr. Small?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Tyler Stephen Small who's placed on deferred adjudication in 2023 CR 0029 for the offense of injury to a child, intentionally bodily injury on August 24th, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
State.
Your Honor, on or about the second day of February 2024 in Bear County, Texas, the defendant, Tyler Stephen Small, did then and there fail to report to the supervision officer as directed in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
And Your Honor, the state will waive and abandon the others.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor.
And what is the proposed agreement?
Counsel.
Sorry. Your Honor, the proposed agreement is from probation. They stated a 0 tolerance and roll and bip within 3 days, weekly drug test for 30 days on IVR line, followed by monthly tap and follow recommendations. I believe probation said that you don't do 0 tolerance.
No, I don't. You're supposed to be doing what you're supposed to do.
So what I was going to request is Mr. Small had been about possibly 7 days in jail.
It was a little over 2 weeks.
Maybe show that as a sanction in jail and follow the rest of the recommendations in this case. He is currently working at Chester's Hamburger. He is also enrolled in Lawson's HVAC technical school. He's currently doing very well there. He did, I think that you've already been informed that he did do a drug test this morning where he has tested positive for marijuana, but no other drugs. That's what we're gonna ask the court to follow this recommendation.
Probation?
Yes, Judge. The agreement that the state and defense have made is fine with probation.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Tyler Stephen Small.
Why are you not reporting?
Honestly, I was at Taco Cabana and I had been smoking marijuana with my manager and I knew that I would fail the drug test.
All right,
And I thought that when I went in, I would be drug tested. And
so your answer, how old are you?
I'm 35 years old.
So you know you're not supposed to smoke marijuana. You did it anyway,
Yes, ma'am.
and you're doing it, I guess, while you're at work?
I was. It was at Taco Cabana. When I got the MTR, I went to jail. I talked to my wife and we decided I went to do another job. We went to one that was 2 minutes away.
No,
from
no,
the
no, no,
home.
no.
Oh.
Here's the thing, you're speed talking. So you were doing marijuana at Taco Cabana,
Yes, ma'am.
and that is why the food has fallen off. So what was your job at Taco Cabana?
I was a cook.
Do you think anybody wants the cook to be smoking marijuana over their food? So you and the manager at Taco Cabana are doing marijuana,
Yes, ma'am.
and you decide you're not going to report because you're going to be positive.
Yes, ma'am.
See, you just compound your problem. So was he positive today?
Yes, Judge, it was positive marijuana.
All right, so when did you use marijuana with the people at Taco Cabana? I'm assuming it's in February.
No, I used it up until the point of my MTR. I have not smoked since, but I was smoking every night with my manager.
All right. All right. What is his TAP evaluation? Did he have a TAP evaluation?
No, not yet, Judge.
All right.
We are asking for the TAP to be complete and to follow all recommendations.
All right. Deputy, he's going into custody today. All right, this is what the court is going to do. Court will deny the motion, alternate amend conditions to include a TAP evaluation in custody, follow all recommendations of TAP. And if TAP recommends an outpatient treatment, then that's going to be 90 sober meetings in 90 days. And there's going to be a UA hotline for him until further notice. And while he's in custody too, we can do a referral to felony drug court. And to the clerk, he's going to be in custody for his TAP evaluation and for felony drug court referral.
Judge, if I may, he's no longer at the Taco Cabana job. He left. He has another job at Chester's Hamburger. He's not using marijuana anymore. They have 4 children they're supporting, and he is in a technical school that he's trying to better himself. He was able to get out of jail, post bond, and try to make better. Would the court consider allowing him to remain out to get these conditions done? You could even have him report, or we can have him report daily if you want to have a drug test. We'll show that his level is going down, but he's taking the first step on his own to try to make better progress. We're just going to knock him back.
Okay.
A few more steps.
All right, we can go off the record. Here's the thing. Everybody who comes to this court on probation, what do I tell them? If you have an issue, pick up the phone, let probation know, because to be successful on probation, communication is key. I tell everybody that. I say, if you feel as they're not addressing that issue, you can come in and talk to the court. You didn't do any of those. What you decided to do, and you're an adult, it's not like although I know 18-year-olds, 19-year-olds are considered adult. It's not like you're an 18-year-old or 19-year-old or 21-year-old. You're old enough, you know better. And what you've been doing is been avoiding consequences. And these are consequences for our actions. Now, if you would like, I could send you to prison. So these are consequences for our actions. And what you've shown me is I can't trust you to even report for probation. That is why you're doing the TAP evaluation in custody. That is why you're doing the felony drug court referral in custody. What I can tell you, if felony drug court accepts you, today is Thursday, they'll probably see you by next week. You understand? There are always consequences for actions. And I think you're old enough to, when you make choices, you need to sit down and say, I'm making choice A. What are the consequences for that? You understand? And I don't write the rules for probation necessarily. This whole thing where you can't drink alcohol while you're on probation, even though alcohol is legal, that's not from me. That's from the legislature. This whole thing where you can't smoke marijuana, that's not from me. That's from the legislature. And I know people think, it's just marijuana. But look at you. You standing before me using marijuana every night at the Taco Cabana instead of making people's food properly, which is why I probably had some hair in my food. But you're doing that. And guess what? Going home smelling like marijuana with your children. And now you before me telling me you have children. Those are consequences you should have been thinking about. And you're on deferred adjudication for injury to a child. Do you understand? All right, good luck to you. All right, so Mr. Kuntz, it's the court's understanding that you need more time?
Yes, ma'am.
Okay. All right, so on Mr. Woodard, this is going to be the last reset. So every witness that people need to call, you need to have them ready.
Yes, ma'am.
Ms. Ferguson, on Anthony Woodard, can I have a 30-day reset, please? All right, there'll be no further resets. Both parties understand? So if people need witnesses for this, make sure they're here. Once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome.
Where, Judge? Sorry about that.
All right, Mr. Acosta, my understanding from your attorney is that he wanted further reset so that he can have more time to have more witnesses here. I'm going to give you May 23rd. There'll be no further resets in this case.
Yes, ma'am. That's fine.
All right,
Thank you.
you're welcome.
So I'm supposed to stand.
Here. And that's at the request of the deputies. All right, so all the discovery has been received. Is that correct?
I believe so, Judge, yes.
All right, I need a acknowledgement of discovery. Done. State, were you able to tender an offer?
And Judge, we were just gonna ask for a little bit more time. We did talk to defense just because this is a case that we are gonna have to go to administration on.
All right, Ms. Ferguson, on 1 Rios, can you reset this for 45 days?
Thank you, Judge.
All right, on that date, you all will need to be prepared to tender an offer.
Yes, ma'am.
Thank you.
And likely, Judge, if we were able to go to administration earlier than that 45-day, we'll let defense know.
All
make
right.
sure they're aware.
And then just set it on the record. Thank you for dressing appropriately for court.
Thank you.
All right, what date, Ms. Ferguson? All right, we'll be back on June 3rd.
Thank you, Your Honor.
All right, you're welcome. All right, what is happening with this case?
Your Honor, he has a newer indictment that he was indicted about 3.5 weeks ago on a
Yes.
case that I haven't had an opportunity to really review the discovery in that case.
All right, and so are you on all cases?
I'm on both cases.
All right. Ms. Ferguson, can I have a 30-day reset on Ramon Sanchez, please? All right, we're going to come back on May 23rd. State on May 23rd, an offer will be due.
Yes, ma'am.
All right, do you have any questions, Mr. Sanchez? All right, we'll see you back on May 23rd.
Thank you, Your Honor.
You're welcome. Court is calling 2023 CR 8930, State of Texas versus Jesus Lopez. Can I have parties announced for the record for the state?
Casey Garrett, Your Honor.
Defense,
Travis Kettner, Your Honor, we're ready.
are you Mr. Lopez?
Yes, Your Honor.
I'm showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Jesus Lopez who was placed on deferred adjudication in 2023 CR 8930 for the offense of evading arrest, detention with vehicle on November 16, 2023 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. Violated condition number 4 in Nueces County, Texas, the defendant Jesus Lopez did then and there failed to report to the supervision officer for intake as directed for the date of January 16, 2024, violation condition number 4.
How do you plead to that? True or not true?
True.
Do you plead true?
Yes, Your Honor.
We'll waive the remaining violated condition.
Any objection?
No, Judge, thank you. We just have an explanation whenever the court's ready.
No.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
And that is to deny the motion, continue the individual on his deferred with a admitted condition of residential treatment with state ISF.
All right, is that the agreement?
Yes, ma'am, it is.
Are you asking me to follow that agreement?
Yes, Your Honor.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes. Your Honor.
All right, you can lower your hand, state your name for the record.
Jesus Lopez,
All right, so Mr. Lopez, how old are you?
18.
All right, so what is going on with your life? Why are you not reporting?
Your Honor, I got sick and I did report, but I reported through the phone and let my probation officer know that I was sick. He said it was fine. I told her I could go in a couple of days because when I'm not sick no more, she said it's fine. And she rescheduled me for a month later. And I was gonna go to report, but I ended up getting arrested for it.
All right, so what was your illness, if you don't mind me asking?
I have no idea. It was more than likely the flu.
Okay. Do you have family in Nueces County?
Yes.
Right. All right, this is what the court will do. The court will deny the motion. Alternate amend conditions for ISF substantive track. And have you been using marijuana?
I don't use no drugs, Your Honor.
All right. So we'll do it for substantive track. Or are you being 100% honest with the court?
I don't use no drugs, Your Honor.
No marijuana?
No marijuana. You could drug hair follicle me, anything.
Okay. Probation? Mr. Lopez is saying that he hasn't been using drugs, so we'll do ISF cognitive.
And he has been in jail for approximately 2 months, Judge, so
All right. Is there anything else?
no, thanks, ma'am.
All right, we can go off the record. Ms. Ferguson, can you do a phantom date on this? 30 days, and let's see if he's been, yes?
The wait for state ISF, and they know this is at least 40 days. So if we do a phantom date, it's gonna be like 45 days.
All right,
or
let's do 45 days. All right, let's go back on the record, please. Mr. Lopez, you understand that the wait time for ISF cognitive, that means that there is approximately a 40-day to 50-day wait. Do you understand that?
Yes.
And do you still wish to wait for transfer at the jail to ISF cognitive?
Yes.
All right. All right, thank you. If there's any other issues, let the court know.
Thank you.
And we're going to put you to come back to this court on June 3rd. It's not going to appear in the system because if it's in the system, then it'll stop you from being transferred. But that's just for me to make sure that you appear, okay? And that you transferred.
So they don't lose track of you.
All right, thank you.
Thank you, Judge.
This is a request for early termination. Has he done a UA?
Yes, he was clear, Your Honor.
Okay. All right, you can unfold your hands. I've never been to Chicken Express.
It's over there by Stone Oak area. It's kind of far from here.
Is it good?
Yes.
Okay.
I'm the general manager, so I take pride in it.
Ah. State on Mark Rene Hernandez, he's done a UA, he's negative. Do you have any objections to early termination? Have you had a chance to review it?
No, Your Honor. No, I haven't had a chance to review.
All right, if you'll confer with them, he's on probation for marijuana.
Judge State has no opposition.
Okay, and did you confer with probation too?
I did, yes, Your Honor.
All right, and did they have any objection?
Not that I was aware of, Your Honor.
All right, what have you learned since being on probation? Don't come back here again.
Yeah. Pretty much just not doing the thing. Well, honestly, when I first got put on, I was going through a tough time. Like my dad had just passed and, you know, stuff was just difficult for me, but it's been 2 years since then. So I coped with it, you know, doing much better in life now than I was back then. So.
All right, that's awesome. I'm glad you did very well. Whenever people are placed on probation, I know the state is hoping that you complete everything. I'm hoping that you complete everything and you're successful. So congratulations. I've signed the motion to terminate you, so you are done.
Thank you.
Terminate sounds like such a bad word. It's like-
In this case, it's not a bad one.
All right, have a great rest of the day. Don't go out celebrating, okay?
Thank you, Judge.
All right, bye-bye. A, State of Texas versus Aria Eden Frosto. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Peter Calvarola from Ms. Foster, Your Honor.
And are you Ms. Frosto?
Yes.
Counsel, did you, I'm sorry, Ms. Frosto, I'm showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Aria Eden Frosto who was placed on deferred adjudication in 2023 CR 01688 for the offense of burglary habitation on May 1st, 2023 for a term of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 42 in Bear County, Texas. The defendant, Aria Eden Frosto, did then and there fail to report to the supervision officer as directed for the weeks of September 25th, October 2nd, October 9th, and October 16th, 2023, in violation of condition number 42.
How do you plead to that? True or not true?
True.
And Your Honor, oh, sorry.
Do you waive?
Yes, ma'am. We waived the other violation alleged in the motion.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 42, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? You need to speak up.
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 42?
Yes, Your Honor.
Court will find violation of condition number 42 true. Is there a proposed agreement?
There's not, Your Honor. The state is asking for a cap of 8 years in the prison, and I know the defense wants to ask for something else, Your Honor.
All right, defense, what are you requesting?
Yes, Your Honor. My client is requesting that, respectfully requesting that we possibly continue on probation.
Okay, you're gonna need to speak up. And everyone, you need to whisper. We're on the record. And if people are having reunions instead of chatting about cases, I'm gonna ask that you hold off on your reunion talks. Yes.
Your Honor, respectfully, my client is requesting that she be reinstated on probation and subject to any programs that the court might deem appropriate. My client would also like to address the court if.
All right, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Aria Eden Frosto.
All right, what would you like to say?
I stand before you today to ask you to reinstate my probation and or give me a monitor to show you that I've matured since being 17. While being incarcerated, I have been working on my GED. I've also taken anger management courses and I've had good behavior since being incarcerated and always try to behave myself even on the outside. For being only 19, I am very mature for my age and I know I have a lot of potential. I also know my worth as a mother and a young woman. When it comes to being a hardworking, sophisticated woman, I plan on going to college when I am released, also to do is what I need to for probation. I have an interest in cosmetology and plan pursuing that as my career. I have a 3-year-old son that needs me at my best version of myself and looks up to me. I have 2 younger sisters, 14 and 13, that also look up to me as well. Since being incarcerated, I missed my son's 3rd birthday and my sister's 13th birthdays. They mean the
Okay,
world
let
to
me stop you for a moment. So the main question for me is, why are you not reporting? This whole thing about you missing your son's 3rd birthday and your sister's 13th birthday, that's all on you. So why are you not reporting?
I had a very hard life growing up. I haven't had parents. I haven't known right from wrong most of my life.
So let me ask you this. When is it your choices and it's not the fact that you had horrible parents? When does it become your choice?
No.
When you're 30? And then it's no longer, you can say, well, I had a bad childhood. My parents were horrible. My parents didn't raise me.
I know you're not.
So when does it stop being your parents' problem or your parents' fault? When is it because you're making choices?
I've made very bad choices.
No, I mean, my question is, how old are you now?
19.
All right, so my question to you is, when is it, woe is me, my parents were horrible, when does it become, it's a choice you made?
Right now, Your Honor.
No,
I made
when?
this choice.
When? Because what you're reading, you're giving me excuses as to why you didn't report. Your excuse is you don't know right from wrong, which I don't understand how that's even possible. But your excuse is I don't know right from wrong because I didn't have any parents to teach me right from wrong. And you're 19, correct?
Yes, Your Honor.
So at what age will you stop making an excuse that I don't know right from wrong because my parents didn't teach me? What age will you be when you won't come before another court or somebody else using that as an excuse? Tell me.
I'm sorry, Your Honor. It stops that.
All right, so here's my other question. Why are you not reporting?
I had no transportation and I was trying my best. And I called him multiple times telling him my circumstance, and that was my probation officer.
Let me ask you this, were you eating food? You need to say yes or no.
Yes, Your Honor.
So did you have a job?
No, Your Honor.
So how were you supporting yourself?
As best as I could.
No, what does that mean? How were you eating and supporting yourself if you didn't have employment?
I had my mom, but.
All right, so you had your mom, the same mom who's a horrible parent who didn't teach you right from wrong, correct?
I chose her as my mom. She adopted me, but they had already said I had warrants out.
So were you living with her?
Yes.
And where is your 3-year-old?
He's with me and his dad. Back and forth. I see him on the weekends.
All right. So this is what I'm looking at. When this plea bargain was done, there were many cases that were taken in consideration. Have you paid any of the restitution?
Yes, Your Honor. I paid it when I went to probation the first time. I was paying my probation fees were $80 a month, and my drug fees, and I never came out dirty.
I mean, I just don't understand. You're not reporting. I don't understand that. I know this is your second motion to revoke.
Yes, Your Honor. But
So,
I want
I
to
mean,
change that. I really do. I want to change that.
All right, so I'm sorry, but you're not a good candidate for probation.
Yes, Your Honor.
I mean, this is your second time. You've been given chances. I don't think there's anything else that the court can do for you. I mean, I don't think she has any prior history that would exclude her from potentially a shock probation, but I'm going to find her guilty. And as previously stated, I'm finding violation of condition number 42 true. There's to be no unsupervised contact with minors. And I'm going to sentence her to 5 years in the prison. Give her credit for any time served. Probation, is there outstanding restitution?
I don't have any restitution.
Okay. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, you do have a limited right to appeal, and that's as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes.
All right, and I will tell you this, if we can go off the record, if you want me to consider shock probation, when you're at the prison, you had better be doing something to show me that you're making improvements and that you're internalizing the reason why you were sentenced. Do you understand?
Yes, Your Honor.
All right, and you can talk to her about shock probation.
Yes, sir.
Thank you.